Vice Chair, John Shepherd, are you ready to start today? Yeah, actually today you'll be doing it instead of Jeremy King. He is remote. Jeremy King's remote, so if you can conduct the meeting, or if you would rather for somebody else to conduct the meeting.
Conduct the meeting?
Correct, yes, sir. If you need Jordan and I to help you walk through it, we can help you.
Is Jeremy available to conduct it via?
Jeremy is, and can he do that?
He can conduct it
Okay.
Remotely if he's able to with the technology, all the. So
Okay.
yes, Jeremy can conduct the meeting if the technology will allow it.
Jeremy, are you available?
Can you hear me, guys?
We can.
I think I'm comfortable with conducting the meeting. I don't have a problem with that now that we've got such good technological resources. And John, I apologize for scaring you there. I think I can handle this one.
Good.
And I apologize. I thought that's the way we're going to do business today. So my apologies.
It's all right. I had tried to call John earlier, and I did call Ed, and I know Ed is remote as well. So I'm ready. I have my agenda in front of me, and if you were ready to go on record, I think I can do it from the comfort of remote location.
Okay. We can hear you. We're going to see if we can get the people in the auditorium to hear you. We're going to get public information to turn up the volume. Okay. I think we're good to go. Can you hear me, Chairman King?
I can hear you loud and clear.
Okay. We're ready whenever you are.
I do have the screen in front of me, so I'm gonna minimize it real quick. It says participants on here. Oops, that did not minimize. Give me a second. I'm just going to move it so I can see the board. I'm moving it so it's about where the podium used to be on my screen. And with that said, does anyone have any indication if we have any more commissioners are going to appear either remotely or in person? The reason why I'm asking is I understood Commissioner White was going to appear via Zoom as well. Does anyone have any?
Yeah, I think we're fine.
No, we don't think, and saying no, and
Right.
we would have a quorum with people remote and physically present, so we're able to proceed, and we don't think that Commissioner White will be joining us.
All right, well, I'm ready to go, guys. It's a pleasure. All right, as always, we're going to start our meeting. This is the Pitt County Board of Equalization and Review meeting for May 28th, 2020. We are going to start our meeting with a silent invocation, as we always do. So if everyone would observe this moment of silence. Amen. All right, if everyone would, John, I'm going to have you, I'm going to stand up and I'm going to have John face the flag, and I'll try to lead us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. All right. At this time, I would ask the clerk to conduct the roll call, both virtually and in present in the auditorium.
Andy Piner. Ed Congleton.
Here.
Jeremy King.
Here.
John Shepherd.
Here.
Lauren White. Danny Smith.
Here.
Jay Shackelford.
Here.
All right. It appears that we have, counting the two of us that are remote, we have 5, which is a quorum. We can do business today, which is great because a lot of people have gone to a lot of trouble to prepare their appeals today and technologically to have us here. Gentlemen, you had earlier sent to you, I believe it was sent today, but it may have been yesterday, an agenda for today's meeting, which I hope you had a chance to review. Mr. Clerk, is there any additions to or omissions from this agenda that was sent out by Ms. Heath earlier?
No, we are going to be subject to taxpayers and consent. And maybe this would be a good time to get Assistant County Attorney Jordan Smith to explain our remote rules.
Jordan, why don't you go ahead and explain to him the details of the COVID-19 remote meetings for quasi judicial hearings?
Be happy to do so. Thank you. So one thing is just note for the members, this is being live streamed currently on YouTube and will be on YouTube for forever. So just keep that in mind. One change will be all votes today will be by roll call. That's for members participating remotely and members here physically in the room, which is a little bit out of the ordinary for how we normally do business, but it's required under anytime we have any remote participation. And before proceeding on any case, we will have to obtain the consent of the parties to proceed with the remote hearing. So I would just ask the chairman before any matter to ask if anyone's present, and if so, to obtain the consent, and then we can move forward. If there are no, if there's nobody here to speak on a specific issue, then we won't have their consent. And so therefore we'll just have to defer those items to a future date. And I think that about covers it. If there's any questions, I'd be happy to answer them. I think the biggest change for you though will just be the roll call vote. It'll take a little bit longer time to go down the line, but we only have 5 people, so it shouldn't be too long. So any questions?
All right, Jordan, that was an excellent explanation of that. And I'm thankful that we have some legislation that allows us to do this in these difficult times. And I also am thankful to my board members who are continuing to practice the safe spacing of the 2 chairs I see. So that said, guys, we have nothing else to add to the agenda. I would entertain a motion to approve the agenda as published. Anyone?
I so motion.
Danny, I've got a motion to approve. Is there a second?
I'll second it.
All right, John's a second. Is there any discussion on approving the agenda as published? Hearing none, I suppose this is the time for our first, we have to have a roll call vote on this kind of procedure, Jordan?
Unfortunately, I believe so. The law doesn't carve out any exceptions. So I'd say we have to do a roll call for everything, unfortunately.
All right. Well, then the hearing none, I'll ask for a roll call vote, and the chairman votes yes to approve.
Okay. And I guess, is it fine just to poll the commissioners that are present?
No, I think we need a roll call vote so just go down the line of alphabetical members present, members remotely, however you want to do it, whatever
Okay.
order, but
And if they're absent,
don't call them.
don't call them. Okay. Jeremy King.
Vote for the motion.
Okay. Ed Congleton,
Ed Congleton votes aye.
John Shepherd,
Votes yes.
Danny Smith,
Yes.
Jay Shackford.
Yes.
All right, by the chairman's count, that's 5 votes in favor and none against. So let's move on to the next one of these we've got, which is the approval of the May 4th minutes. As you guys recall, we had a truncated May 4th meeting because of the crisis where we discussed whether or not we could have in-person meetings, and we discussed whether or not we could use technology. It appears we're doing both. So if you all reviewed those minutes that Ms. Heath sent out earlier, then I would at this time entertain a motion to approve the minutes as published unless anyone noticed any additions or omissions.
I motion.
Danny has a motion to approve. Is there a second?
I'll second it.
John seconds it. All right, we've got a motion in front to approve the May 4th minutes as published. I think we're ready for our roll call vote.
Okay. Chairman King,
I vote for it. Approve.
Ed Congleton,
Ed Congleton votes yes.
John Shepherd,
John Shepherd votes yes.
Danny Smith,
Danny Smith votes yes.
Jay Shackford.
Yes.
All right, the motion once again carries unanimously, 5-0. Now we're ready to move into actually doing our work for the day. Here's we have 9 appeals scheduled today, some on multiple tax parcels, but it appears that we have attorneys today, and we're going to start with our Patheon manufacturing appeals. For my calculation, looking into this agenda, it appeals we have a real property value appeal for 2020, and then a business personal property value appeal for 2020, also a business personal property value appeal for 2019, and a request for a late listing penalty waiver for 2019. So is somebody here for Patheon?
Yes, Mr. Chairman, my name is John Reese. I'm an attorney with the law firm of Bell Davis and Pitt in Winston-Salem, and I'm here on behalf of Patheon.
Thank you, Mr. Reese. We appreciate your presence, and we appreciate you working with us in these difficult times. I think it would be wise at this time, given the notification that the county attorney provided us on the statute, does your client consent to a remote meeting?
Yes, sir.
All right. Well, I think we'll do our best to dispense justice. And I suppose the county consents to a remote meeting as well. Is that correct?
That's correct.
All right. So looking at this thing, I think it's always better to proceed with the real property valuation appeals for 2020. This is a reappraisal year, so we are allowed to choose factors that we don't normally get to look at in non-reappraisal years. So at this time, I would ask I think the way that I want to do this is ask the county to go ahead and present the real property appeal, the county's appeal for the 2020, sorry, not the county's appeal, but the county's valuations for the 2020. Let the taxpayer respond with their evidence. And then generally we will give the county a chance to rebut, and if needed, the taxpayer a chance to rebut. It's been a while since we've had revaluation year appeals, so it always is good to get a little bit of a refresher. So if that meets everyone's expectations, I think we'll begin. So why don't somebody tell us about the real property valuation for Patheon in 2020?
Chairman, the county is going to be represented by Attorney Robert Adhan, and I'll let Mr. Adhan introduce himself and present the county's case.
Thank you. I'm Robert Adhan. I'm with the law firm of Ruff, Bond, Cobb, Wade & Methuen. I hope everybody can hear me. Is that all right?
I can hear you loud and clear.
Good. Okay. I appreciate the opportunity to appear remotely by Zoom, and I think it's great that we have this technology and everything. And I appreciate Mr. Cockerice's consenting to my appearing by Zoom also. I talked with him 2 days ago, and he had no problems with this. So anyway, Pitt County has retained our law firm to represent it in multiple appeals regarding the Patheon pharmaceutical facility there in Greenville. The real property appeal that's at this hearing here, the 2020 reval. There's also a 2018 appeal of the real property value that is pending before the Property Tax Commission. And then there are several business personal property appeals that are pending at the, well, one that's pending at the Property Tax Commission also. So that's how our firm got involved. The value of this facility is $79,871,256. And that value was established using the schedule of values for Pitt County for the revaluation. It's a complex pharmaceutical manufacturing facility with multiple buildings, and the value was established. It had prior, the 2016 value, I'll kind of go a little into the background. The 2016 value was a little over $68 million. And then there were some improvements to the property in 2016 and 2017. And the Board of Equalization and Review in June of 2018 set the 2018 value at a little over $76 million. That $76 million value has been appealed to the Property Tax Commission. And now once the revaluation came into play January 1, 2020, the value increased from 76 million to a little over 79 million, $79.8 million. So that's sort of the history of the value. Certainly it seems the increase in value from 76 million to 79 million seems consistent with economics and the prosperity that we've had over the years. And if there's any specifics that the county wants, I can have the real property commercial manager speak to any specifics regarding this property if you need so.
This is Commissioner King. My question is the current county assessment on this, to get this right before I let the
Right.
The taxpayer speak, is $79,871,256.
Correct.
And the county's valuation is obviously presumed to be correct under the statutes. The burden is on the taxpayer to do it. And you're saying that there was a previous value from the last cycle that we had after improvements were made, physical improvements were made, that was $76 million in June 2018 that we set. And I do remember that appeal. We set that, and that is currently being appealed to the PTC, correct?
Yeah, yes, that's correct. That's on appeal to the PTC, and Mr. Cockle Reese is representing Patheon in that.
And I guess my question would be that is the $79 million valuation just a result of the overall value increases overall, or it's not been any additional improvements made that are calculated into the real property value since the 2018 valuation?
I don't believe so. I don't believe so. It's just the increase is a result of the change of the schedule of values for 2020 as opposed to the schedule of values for 2016.
All right. Does the county have any? And I'm a little bit I think I'm probably at an advantage in here. Does the county have any documentary materials they need to present to the members that are there?
I don't at this time. I will leave it to the staff if they have some they want to present.
All right. Is someone from the staff there, or that I could?
Is Sam, is Rod there?
Rod is here, and at this time, would we need to swear Rod Towell in?
If he's going to testify, the answer to that is yes. And if he wants to present his documents, the answer to that is it's probably time to swear him in.
Okay, I want to ask Ann Heath to come forward and swear in Rod Towell.
Do you affirm that the testimony you shall give to the board shall be the truth, the whole truth, and nothing but the truth?
My name is Rod Tugwell. I'm commercial manager for Pitt County Tax Office. Just a little bit about the company. We all know it very well. It's one of the leading pharmaceutical manufacturers in the world. It is the facility here in Greenville is 1.4 million square foot on about 143 acres. To address the change in value from 18 to 2020, which was, of course, our reval year, and all values in the county changed, or at least most of them did, in some form or fashion. And for this particular property, since 2016, there had been $17 million in building permits issued, and which possibly could have a significant effect on the final valuation. And we have not been able to really adequately we hadn't been able to adequately see what was actually done, whether there was any improvements to the property, whether there were just alterations, or but we were thinking that certainly there was some change in valuation as a result of that those building permits. And this board in 2018, as was just mentioned, established the value at $76 million. And there's an appraisal out there that we have reviewed, and we do not think the board should consider that appraisal because the effective date on it is January 1st of 2016. And so our valuation, our currently valuation, which is just under 80 million, is we ask that you hold that value and not consider the 2016 appraisal.
Okay, Mr. Tugwell, do you have any documents you want to give to any of the board members or anything?
Well, I previously submitted copies of the appraisal, copies of our evaluation. So that's all we have at this time.
Okay, and do members of the board, I have been emailed the documents earlier. Do you, members of the board that are present in the auditorium, do you have a package of documents with regard to this appeal?
Should be these in the accordion folder. I believe all members do, Chairman King.
All right, and these should have the documents both from the county and from the taxpayer appellant.
Chairman King, this is Sam Crum.
Yes, sir.
I'm not seeing that in our packet, but I do think those that are remote do have it, but I think Mr. Cockeries actually has, do you have copies of them?
Yes,
I have appraisal.
copies of our submission.
Yes. And is it okay for Mr. Cockeries to distribute them at this time or give them to the clerk and I can distribute them?
It's up to you and Mr. Cockeries. I've got them in front of me. I think Mr. Cockeries is going to refer to them in his hearing. So whatever, it's getting ready to be his turn, I would say. So if he's comfortable passing up the documents that he wants the board to see, I think that this would be an appropriate time to do so. People on the board, I think that they'll refer to those. My guess is that we're going to be referred to those documents during the course of this appeal. I don't think you need to sit down and read all the way through them right now, but you certainly are going to want to have them in front of you so you can refer to them during this case. With that said, I think the county has presented, this is a reappraisal year. This is a real property valuation. County's value is that they've requested is $79,871,256. This is on the real property, and its valuation is presumed to be correct, but Mr. Cockeries can present evidence and make his arguments in favor of his client. And with that said, I think I'll recognize him to do so.
Thank you, Mr. Chairman, members of the board, both here and remotely. Again, my name is John Reese. If I could take just a second, again, although right now we're dealing with the 2020 real value, we also have a 2018-2019 business personal property, 2019-2020 business personal property appeal, and a late listing issue. And just for your benefit, Mr. Chairman, I'm going to spend most of my time today talking about the late listing penalty, but I will touch on the valuation issues. But by way of background, again, I'm assuming most people in this room from here are familiar with this pharmaceutical manufacturing plant. I think it's important to understand that plant, the original parts of it date back probably 30 years or more. So there, in our opinion, is a lot of obsolescence that is inherent in the buildings and, for that matter, in the business personal property when we speak about that. We have appealed the real estate for 2018. And as you may be aware, I'm sure, that appeal will carry forward to 19, whatever resolution is resolved there, either by settlement or by hearing. But obviously 2020 is a reval year. And so if we want to protect our rights to any future adjustment that might relate back to that 2018 case, we have to appeal. So that's what we have done. So to be perfectly honest, we have not undertaken to get an appraisal done of the property as of January 1, 2020 at this time, because again, we're hopeful that either by settlement or hearing, we will resolve the 2018 case on the real estate, and that will allow us hopefully to negotiate a settlement on the 2020 case at the same time or following that. But for purposes of this hearing, as Mr. Tugwell mentioned, we have done an appraisal for the property as of 1/1/2018. That reflects the schedule of values of 1/1/16 plus the improvements from that date to 2018. And that value was approximately $49 million. So we think that is the value that should be the value for the real estate for 2018. There have been some improvements in the property since 1/1/2018, but we don't believe that they can considerably or materially affect a change in value. So for purposes of this hearing today, we would submit that the appraisal that we had done is good for 2020 also. And so we would submit that the value should be in the range of $49 million for 2020 also. And in the packet, I should have said at the beginning, really there are 2 pages on top which sort of summarize my arguments to you on all of these cases. But behind that is a copy of the real estate appraisal, again, for the 2018 year. And also, as we'll talk about in a minute, a copy of the appraisal relating to the business personal property for 2018, which again, we would say bears on the value coming forward. So that's all I have at this point in time, Mr. Chairman.
All right, Mr. Cockerice, I think that I appreciate that truncated argument on that one. And if I can recap it, just to understand, the county's valuation is based on, to be honest with you, us accepting the $76 million valuation from 2018. The taxpayers appealed that value already, and it has moved up the chain to the PTC. So I guess to a certain extent, the 2020 valuation is going to rise and fall on the actual determined or negotiated valuation for 2018. So you guys procedurally are making your appeal on the new revaluation, but you're not really presenting a lot of evidence on it, because if the property tax commission comes down with a different decision than we made in 2018, it's going to directly affect what the 2020 valuation is as well. Is that a fair encapsulation of your argument on the real property valuation?
That is correct, Mr. Chairman. And that also applies just for the purposes of moving things along with respect to the business personal property appeal for 2019 and the business personal property appeal for 2020, which are also before this board today. And we have essentially the same argument there, which relates back to our 2018. Again, the 2018 business personal case and the 2018 real case are before the Property Tax Commission. I think the result of that case through hearing or settlement otherwise will impact these years. We have to continue to appeal these years if we want to preserve our right to have that whatever result happens in the earlier year carry forward to the future years. So that's why we're here. But I've talked with Sam and indicated that I was not going to spend a great amount of time arguing about the value of those 3 years of tonight.
Okay.
But I'm happy to answer any questions.
Sure. And I think given the nature, first thing is I appreciate that. And I think the board does too. We understand that this is going to be ultimately determined above our level. And we certainly like when people make our jobs a lot easier, but we also want to protect the taxpayers' rights procedurally and make sure that you've checked the right boxes to proceed up the ladder. Question, is Patheon still the current owner of the property?
Yes, sir.
That is correct. Okay.
So just for informational purposes, Thermo Fisher, another company, bought Patheon, but they bought the company. They didn't buy the assets from the company. Patheon is still in existence and still the owner of the assets.
So it was kind of a stock purchase instead of an asset purchase.
That's my understanding. Yes, sir.
All right. I was a little confused about that reading through the materials, but I understand now we have the right parties and we are in the right procedural framework. All right. With that said, I think that I think we've got the arguments on the real property and we can go from there. I don't think we need to take a vote on the real property bill yet, unless somebody on the board disagrees with me or has a lot of questions. I think I'd like to move into the business personal property appeals for Patheon. Does anyone from the board have any want to do it a different way or have any confusion on the real property valuation issue? All right, well, let's move to the business personal property and let's have the county tell us what they think the business personal property is, which I think it would go to you, Mr. Adhan.
Okay, thank you. Yeah, and again, as as Mr. Cockery said, yeah, a lot of these valuation issues really are not in dispute. They matter procedurally in order to protect the Patheon's rights as we proceed with the appeals that are pending for the Property Tax Commission. The 2019 business personal property value was set. It's the board members, I'm sure, are aware. Taxpayers are required to list their property every year, and the listing forms that the taxpayers provide are broken out by different sets of categories: computers, equipment, furniture, supplies, all of that. And Patheon has provided the listings for 2019. It was late, but they did provide it for 2019. And based upon that, the listing that we got from Patheon, the county determined that the value of the business personal property for 2019 is $243,157,828. $243,157,828. That is the value based upon the listing provided by Patheon for 2019. The listing for 2020, the current year that Patheon provided, the value was increased to $288,116,228. That's $288,116,228. And obviously that shows that there was some property acquired in 2019 that increased the value for 2020. So those, as has been said often already today, the county's values are presumed to be correct. And I can, if you want to get into specifics on why the Patheon's values are incorrect, I can, but I don't think that's really necessary at this time. And I will ask if Renee Toppin, if she's there, if she has anything to add. I'm not sure if she does or not.
Mr. Adden, she just added that she does not.
Okay, so this is the chairman again. The county's presumed that the business personal property is already under appeal for prior years as well, correct?
For 2018, yes, Mr.
Yeah.
Chairman.
Yes, that's correct. Yes.
And to a certain extent, the arguments are going to be the same. The value of the business personal property that they had in 2018 is the same plus additions in 2019 and 2020. So if the PTC decides that the taxpayers' arguments hold water and reduces the value there, then it's going to definitely affect the 2019 and 20 valuations, correct?
That's correct. Yes.
All right. So all right. That sounds good to me. For the record, I'd put in that the value that the county says is the value of the business personal property for 2019 is $243,157,828. And for 2020, $288,116,228. Is that correct?
That's correct according to my notes.
All right. I will hear from Patheon then. Mr. Cockery, you have the floor on the valuation, and we are certainly going to let you all argue about the late listing penalties too. But if there's anything you can add to us on the business valuation, you are free to do it.
Thank you, Mr. Chairman, and I will try to be brief. For those that are looking at my materials, if you look halfway down the first page, you see our taxpayers' positions. Number one dealt with the real property, so I'm now going to deal with subparagraph 2 and 3 here. And just as a matter of background, we appealed 18. The taxpayer had an appraisal done of the business personal property. Now that appraisal did not include the value of supplies and construction in progress. And so for purposes of our 18 appeal, we essentially thought our opinion of value of the business personal property was the value as the listing showed of the CIP, construction in progress, the value of the supplies as shown on the listing, plus our appraised value for everything else. So similarly, for the 2019 value, what we have done is really something similar to that for purposes of this hearing. So we believe, as far as a number goes, that the value of the business personal property as of January 1 of 19 was roughly $171 million, as compared to the county's value of roughly $243 million. And our value essentially is computed by taking the appraised value as of 18, adding 100% of the value of any improvements prior to 1/1/19, that is in the calendar year 18, and adding in the supplies and the CIP. So that's where our 171 million and change number came from. Again, taking our appraised value for 18, adding the additions to business personal property that happened in the calendar year 18, and adding supplies and construction in progress. Similarly, for 20, we have come up with a value of almost $228 million. Again, that compares to the county's value of roughly $288 million. And again, our process was the same in coming to our value. That is, we took the 2018 appraised value, we added the additions in 18, the additions in 19, we added CIP, we added supplies, and that came to the almost $228 million. So that we think is our best evidence of value for those 2 years at the present time. I would point out, as Mr. Adhan mentioned, the process that the Department of Revenue suggests that the counties take in coming up and valuing business personal property is the taxpayer lists their business personal property in January of each year at original cost. The Department of Revenue provides schedules that trend up for inflation and depreciate down for age of those original costs. And so what the county has done, which is similar to what every other county does, as far as I know, is take those listed costs and run them through the schedules that the Department of Revenue has suggested that they use to come up with a taxable number. However, the real point of disagreement we have with the county is that those depreciation schedules that the state suggests that they use, clearly the state says only reflect physical depreciation, the age of the asset as it gets older. It does not include, it specifically says it does not include any consideration of economic or functional obsolescence. And we would contend that a significant part of the business personal property assets that we're listing at original cost go back many years and have significant, the old stuff has significant economic and functional obsolescence. And so that's really the difference between our two numbers. But we ultimately will argue more about that later, probably.
That sounds like a very interesting argument. I do note that it appears that your valuation increase from 2019 to 2020 is more than the county's increase from 2019 to 2020 in raw dollars. It appears that most of your appeal must be related to the value of the 2018 and before equipment. Plus, I would guess that it's the obsolescence argument carries you forward. But if I'm looking at the increase from 171 to 228, I think that's higher than the county's got from the 243 to the 288. So it seems like the taxpayer certainly acquired some new equipment, but I understand the argument. Does anyone from the board have anything for Mr. Cockle-Reese with regards to the valuations on either the real property or the business personal property? Ed, do you have anything? I see it with a hand.
Yes, my question is that if Mr. Cockle-Reese says that the equipment is obsolete, is it still being used in manufacturing processes at the plant?
I think that's a fair question. Mr. Cockle-Reese, can you address Mr. Conklington's question?
Yes, I can. I think the correct answer to that is some of it is no longer in use, but some of it is still in use. And it is not obsolete in the sense of it is not usable. It has obsolescence, which means it is less usable than whatever the new piece of equipment that does the same thing is. So what that means is, as you are aware, the statutes in dealing in telling us how we are supposed to value business personal property says simply that it's valued at fair market value. That is what it would sell for in the market, willing buyer, willing seller, all those sorts of things. And so it doesn't say anything about taking original cost and depreciating it or anything like that. But Our point being that some of this business personal property is very old, and therefore, if you were to sell it, it would not get the dollars in value that the state schedules say that it would. Because the state schedules, unlike IRS income depreciation that you may be familiar with, which ultimately depreciates to zero at some point in time, the state schedules never depreciate to zero. They have a residual value that stays there as long as you're using the property. And, you know, that makes sense as far as it goes, but that residual value we would submit in a lot of cases does not reflect the value at which the property would sell. And that's really the question. What would the property sell for in the open market?
And this argument is pretty much with the schedule of values overall. It's not specific to Pitt County. Pitt County is following the DOR regulations, but it's with the actual schedule of values itself, which I would imagine that the taxpayer would feel is somewhat arbitrary and not accounting for the functional obsolescence. Is that a fair recap of the argument?
It is, Mr. Chairman. Sorry if I interrupt you. It is. I would only point out that, again, even the directive from the Department of Revenue that goes out to the counties with respect to these schedules says that it does not even attempt to reflect functional and economic obsolescence. And so the county is tasked with investigating that and making their own determination as to whether it exists or not, and if so, how much and all that sort of thing. Unfortunately, not being critical of Pitt County, but my experience with counties in general is they just take the schedules and apply them, and they say that's all they have to do.
All right, I think we all understand. Does anyone else from the board have any questions for Mr. Cockle-Reese?
No.
Hearing none, does anyone from the county have any questions or have anything else to respond?
Yeah, I would like to just address the latter points that Mr. Cockle-Reese has made, just to make sure there's no misunderstanding. As he said, the county takes the listing, we apply the Department of Revenue schedules. If the taxpayer shows us or convinces us that there's other obsolescence or physical depreciation that needs to be taken into account on particular equipment, we would certainly take that into account. It's not just we're going by the state schedules, we're not going to consider anything else. If it's up to the taxpayer to point out to us any obsolescence and stuff. I'd also point out there's another thing that's in play here. The theory that this equipment, you value it as if you took the used equipment out and sold it on the marketplace, was shot down by the Property Tax Commission last year. In March of 2019, our law firm had represented Mecklenburg County in a business personal property appeal regarding Harris Teeter and the equipment in the Harris Teeter. Mr. Cockle-Reese was on the other side and made those same arguments to the Property Tax Commission. The Property Tax Commission ruled against the taxpayer and ruled that that the marketplace for used equipment, the idea of taking the equipment and selling it in the open market, is more of a liquidation value, not a true value. And that's just one. And that Harris Teeter decision is on appeal now to the Court of Appeals. I think the Court of Appeals even decided the case, or had the case in chambers to make a decision back in end of April. They are deciding it without oral arguments. They were going to have oral arguments, but decided against it. So this issue about whether or not you should value this as if you took the equipment out and tried to sell it on the open marketplace, that's been rejected by the Property Tax Commission. And I would submit that the county's value should be upheld.
Okay. And Mr. Cockle-Reese, do you have anything to respond?
Very quickly, I would only say, and Mr. Adhan wouldn't be surprised to hear me say that, I don't agree with his characterization of the Property Tax Commission's ruling in that case. But be that aside, it's on appeal, and hopefully we'll be corrected on appeal.
I think Sam may have copies of that decision if the board would like to review it.
Well, I think I understand where we're at. I hate that we did not have oral arguments in that one. That seems like it might have been an entertaining thing for those of us who enjoy this type of thing to watch. That said, I'm going to close the hearing to evidence as far as the valuations go on the real property and the business personal property for tax years 2020 on the real property and 2019, 2018 on the business personal property. I think I'm going to let you go ahead and make your arguments. I don't think we need to vote yet on the real property or the business personal property because of the procedural position we're in. But I think at this point, I'd like to hear the arguments on the late listing penalty. And can someone refresh the board as to why someone from the county refresh the board as to why there is a late listing penalty and what it is and what the requirements are?
Okay, yeah. What happened in this case, and the facts really aren't in dispute. As Mr. Cockery said, Thermo Fisher purchased Patheon. I'm not sure exactly when that was, but then in March of this year, March of 2019, Thermo Fisher listed the business personal property. The form, when they listed it though, they did not list the personal property by categories and historical cost, going by the different years, you know, saying, oh, this property, as Mr. Cockery said, some of this property has been around for 30 years. Instead of listing all the historical costs by years, they just lumped in one cost of, like, I want to think it was like $380-some million that they acquired it in 2018. And that was obviously wrong. And so there were some discussions between the county and Thermo Fisher and Patheon. So there were really two things wrong with it. Number one, it wasn't Thermo Fisher's property to begin with, although they said it was theirs. I mean, they submitted a listing signed by an officer of Thermo Fisher saying, we bought $388 million worth of business personal property in 2018 and are listing it for 2019. And it wasn't until later down the road where Patheon says, wait a minute, no, that was all wrong. The property is ours. Thermo Fisher did not buy the assets, they bought the company. And so all this business personal property is ours, it's historical cost. And in December of 2019, they submitted the listing. So they were 11 months late or whatever. And so clearly they were late in listing. Thermo Fisher, Mr. Cockery asked the Board of County Commissioners to release the bill to Thermo Fisher, because Thermo Fisher got a bill based on $388 million of personal property. And Mr. Cockery's asked the board to release that, saying it was an illegal tax because Thermo Fisher did not own the property. That's sort of kind of when my firm got involved with all of this. Janice Gallagher contacted our firm and we talked about representing. And so the very first thing we had to do was resolve the fact that Thermo Fisher had a bill out there based on $388 million of business personal property, and they were asking the Board of County Commissioners to release that bill on the grounds that it was an illegal tax. Arguments could be made both ways. In the meantime, Patheon had submitted a corrected listing showing the $288 million worth of value in December. And so even though you could make arguments both ways, the county commissioners on the tax assessor's recommendation, our recommendation, went ahead and agreed that it was technically an illegal tax because Thermo Fisher did not own that property. And if you tax somebody for property they don't own, that would be an illegal tax under General Statute 105-381. You can release that tax. And so we did that. And knowing that as soon as we did that, we were going to turn around and send a new bill to Patheon on the $288 million of business personal property, and that bill would include penalties because they were late. It's clear they were late. Now, as the board knows, under 105-312, the board has the opportunity to compromise and to waive penalties. You could waive the penalty completely, or you can compromise it. The county's position on all this is that the penalties were properly assessed. It's, I think, about $195,000 worth of penalties. There's no question the listing was late. This whole problem was not created by the county. The whole problem was created by Thermo Fisher and Patheon. It took months and months and months to resolve it. It went from filing the Thermo Fisher listing in March till December, filing of the new listing by Patheon. The county staff incurred time, county attorneys incurred time, the county retained our firm to represent. We're against a waiver of the penalty. To the extent I'm sure Mr. Cocklereese is going to make an impassioned argument in just a minute. And to the extent he is able to persuade you at all, we would ask that any reduction be very modest. So,
Thank you, Mr. Adhan. Out of curiosity, I'm looking at the materials from 2019. It looks like it was received by the county in March 19th, 2019. This would be the Thermo Fisher document.
Yes.
So the date was timely, but the taxpayer didn't actually own the property. Is that correct?
The date was timely, and the taxpayer later said we don't. Later they submitted an affidavit saying, "Hey, we don't even own this property." Once they got a bill for it, they didn't own it.
But is it also your argument that not only was the taxpayer the wrong taxpayer, but also that the form wasn't completed properly and that you couldn't evaluate the property, and it actually was for $100 million more of business personal property?
Yeah, and it basically throws the whole budget process into play, into disarray. I mean, and so basically what Thermo Fisher did is really not relevant to, if you think about it, it's not real. It sort of explains why Patheon was late, but they were way, way late. I mean, they didn't file this listing till December of 2019. And yeah, what Thermo Fisher did to start this debacle really isn't relevant. It's just the excuse that Patheon will make as to why they didn't do it. I guess they thought Thermo Fisher was going to do the listing, but anyway.
Does anyone from the board have anything for Mr. Adhan right now? Any questions for him on the county's position on the late listing penalty? All right, Mr. Cocklereese, your opportunity to give your impassioned argument in behalf of your client. Here it is.
Thank you, Mr. Chairman. So, Mr. Chairman, members of the board, I think it is important to repeat one thing that Robert said, which is under the statutes, this board has the discretion to waive the late listing penalty. And that's what we're asking you to do. First of all, we fully, yes, sir.
What was the word before penalty?
Late listing.
Oh, late listing. Okay, thank you.
I'm sorry.
Let me cut in real quick. John, this is we have the form that we send out every year that every person in Pitt County, if natural person, if they have a business personal, a sole proprietor has that, or a corporation or an LLC, they have to fill out their annual listing each year. And we send them out. It's got that notice on the bottom of all the property, like airplanes that we send out. If the taxpayer doesn't send in the form by the required deadline, there's a penalty on it. And it is generally, if I recall correctly, Jordan may be able to correct me, a 10% penalty for failure to list. Or you could get one that was an underlisting penalty. For example, if you had, $1 million of property and you only listed 500,000, there'd be a penalty on it. And that penalty is prescribed by statute for purposes of you missed the deadline. And our board, because of the statute, our board has the ability to waive these penalties for taxpayers if we hear their argument and we say there are some extenuating circumstances as to why it wasn't filed in a timely manner or there was something else irregular in the process. And we have heard those for the last 16 years. But this is, Mr. Cocklereese has presented on his client why the county said, hey, we didn't get it until December, although there was one that was filed by Thermo Fisher in March, which would have been timely. They just didn't own the property. So I think that's going to take you back to Mr. Cocklereese making the argument as to why his client should be forgiven for their what appears to be some kind of clerical error.
Chairman King, if I may, just real quickly, for the board's benefit, we have been, I think both parties have referred to this as a late listing penalty, which people often do. Just for the board's purposes, it's truly at law, it's a discovery, a 1-year discovery. So that's what kicks you into the discovery statute of 105.312K that gives you the power to compromise. The board may be more familiar in instances where the county hires a firm and goes out and discovers property that has not been listed for a multitude of years. That is not the case here, but a late listing penalty is simply a 1-year discovery that puts you in the discovery statute that gives you the ability to compromise some, all, or nothing. So I just feel like some of our board members may be more familiar with the term discovery versus the late listing penalty.
I appreciate that because that is important. But I was about to say Patheon / Thermo Fisher because it's really, although for legal purposes, they're separate entities. Thermo Fisher owns Patheon, but it's the same company in a global perspective. We fully admit that we screwed up. We filed an incorrect listing. We did file it timely by the deadline, but it was wrong in 2 respects. As Robert Adhan has indicated, it reflected that Thermo Fisher owned the property, which was not true. Patheon owns it. And it had another number on there and didn't have the historic cost information. So it was clearly wrong. And once we determined that, we began efforts to try to correct that. That caused a lot of other issues that Robert was talking about in terms of a bill got issued to Thermo Fisher and whether that was, a proper bill and all that. The county just couldn't simply tear that bill up and say, we're going to start over. That's why we had to go through the release process and all that. But that's not really relevant, except to the extent that we admit that we made a mistake and we didn't file the listing properly, although we did file it timely. Subsequent to that, we worked to get the proper listing done by Patheon with the historic cost, and we got that filed. And also, in addition, as soon as we got that filed, obviously it was going to take some time for Pitt County to determine whether they were going to basically keep the existing bill that they had for Thermo Fisher or not. And if they were going to accept the new Patheon listing to get a bill out, that was getting toward the end of the year. In an effort to be a good corporate citizen, Patheon said, well, assuming you accepted this corrected listing, as I would call it, what is the tax due on that? And the county calculated that, and we paid that prior to the end of the year in an effort to be a good corporate citizen, because obviously it was a mistake on our part as far as the original listing went. But we moved to, as best we could, to get that corrected, to get the books cleaned up, so to speak, to get the tax that should have been paid determined, and we paid that, and we paid it in full except for the late listing part. And furthermore, I would point out that, I believe Patheon historically has done all their listings correctly, timely, and all that sort of thing. So this is a one-time screw up, to use the legal term. And we would ask that the board exercise its discretion to waive the penalty for this one-time screw up. Yes.
You mentioned several things that happened after the screw up. Can you provide us a timeline of those events?
Okay, so the original listing, I'll call it the Thermo Fisher listing, was in March before the due date. I can't tell you exactly when we became aware, or I became aware that it was incorrect, except that ultimately we did get a bill for that property, which I think caused us to say that couldn't be right. And so we began to investigate. So then in the summer and fall, we were working on getting the proper listing done and discussing getting that filed with the county. We ultimately didn't get it filed until it was either late November or early December.
And payment was made when?
Payment was made before the end of the year. I don't remember exactly when, but before December 31. And so again, for our position is number one, we admit we made a mistake. People do make mistakes, even big companies. Number two, we have a track record where I don't think this is a habitual thing or even has happened before. So we would ask you to exercise your discretion. We would indicate that, we went above and beyond to go ahead and pay the tax before we even got the bill. So the county would have that money in the till in the year. I'm happy to answer any other questions.
Does anyone from the board have any? Go ahead.
Yeah, there was some discussion that when they were purchasing the company, they felt like they were attributing $388 million to the business personal property there. Is there truth to that? How did that come about?
I do not know where that number comes from, to be honest. I suspect, when for federal income tax purposes, when one company buys the stock of another company, then for purposes of the purchase company's books, that purchase price has to get allocated among all the assets, which would include the real estate, the personal property, the intangibles, the goodwill, all of that sort of stuff. Maybe it came from there, but quite honestly, I don't know where that number came from.
Does anyone from the board have any more questions for Mr. Reese? All right. Does the county wish to be heard in any kind of rebuttal for that?
I would just, I looked at my notes and actually the number was 362 million, not 388 million. And it was based on basically the listing that Thermo Fisher, for instance, it said under machinery and equipment that it had added $275 million of additions for 2018, and that it had added $3 million of furniture and fixtures in 2018, and $38 million of computer equipment, and then some other costs. And that's how the 362 million, they just said that they acquired everything in 2018 as opposed to doing the historical cost. And so that's how it's kind of got the screw up, the first screw up, and other than the fact that they didn't own the property.
Somebody screwed up pretty bad, because my guess is that they probably got a tax bill generated in August of 2019 for the $388 million of valuation sent to Thermo Fisher out of nowhere. So I would think that was a bad day for whoever did that.
Yeah, they got a tax bill of $2,921,000 based on the $362 million of business personal property. The ultimate bill that Patheon paid, the ultimate tax payment was $1.9 million. So it was $1 million more than they expected. So and
they would not have gotten that bill until the tax bills come out, because the county doesn't set the rates. So they wouldn't have gotten the bill until late August of 2019. So that would have triggered the discovery of the screw up, I would say. So
I believe, in Sam or Renee can correct me if I'm wrong, there were some discussions after the Pitt County received the listing that there were issues with it, and discussions in April and May of 2019, even before the tax bill was generated.
Does anyone know when the county actually released the released the tax bill to Patheon? I'm sorry, to Thermo Fisher.
It was done at a Board of County Commission meeting, I believe in March of this year, early March, like March, the first county commission meeting in March.
Okay.
We sent a letter to the county. Janice Gallagher, the Pitt County attorney, sent a letter to Mr. Reese on March 9th, 2020, that the Board of County Commissioners authorized the release of that 2019 bill. Yes.
Okay. All right.
Mr. Chairman, if I could just say this, certainly we appreciate Mr. Adhan and the county's consideration of that release. We think that's the proper thing that should have been done to get things back to where they were correct. But nonetheless, they didn't necessarily have to do it, or they could have fought it. We appreciate them being cooperative and helping us try to get back to where things should have been to begin with. And again, the correct amount of tax paid. And again, hopefully this is a one-time mistake, and we hope not to repeat it again. And therefore, that's why we're asking for your consideration in waiving the late listing penalty, which is not insignificant, obviously.
All
Mr.
right.
Chairman, how much
ahead.
is that penalty?
It's $195,000, I believe.
That's my understanding, somewhere in the neighborhood of $200,000.
And that would be, Ed, that, as Jordan discussed earlier, that would be based on 10% of the value. It's an automatic statutory penalty, 10% in the year of discovery, 20% in year two, you know, that 10, 20, 30, 40, 50, 60 that we have to deal with. So if somebody misses one and they've got $20,000 worth of business personal property, it's 10% of, 10% of that. When you've got as much as they admittedly have, what they're not even disputing, it adds up pretty quickly. So,
Yeah, it was,
go ahead.
the penalty is, the 2019 bill that Patheon actually payment they made was $1,959,850, which was the taxes. And so 10% of that 1.959 is the penalty, the statutory penalty. But again, the statute does allow for a compromise. So
Yeah, all right. I'm going to go ahead and close this one to evidence.
I have a question.
Oh, go ahead, John.
Are the taxes paid on all of the property listings for the years that you're appealing?
Yes, sir. It's my understanding that Patheon has paid the taxes in full while we're appealing the value, and therefore, ultimately, if there's a settlement or a hearing, a board or court resolution that reduces the value, will be entitled to a refund. But we have fully paid the taxes based on the bills presented.
And Mr. Cockle-Reese did testify that the one that's at issue for the late listing penalty, the other ones are not penalty cases. There's only one that's a penalty case, and that's business personal property for 2019. And I don't think there's any dispute that they paid the $1,959,050 before the end of the calendar year of 2019. So that's the one we're dealing with on the penalty issue. And that said, unless anyone has anything else, I'm ready to close this one to evidence. Is anyone else from the board have any questions? Are we ready for discussion? All right, I'm going to close it to evidence. Let's go back to the valuation appeal on 2020. This is the 2020 reval on the real property. The county's, it's a reappraisal year. We can consider a lot of stuff wider than we can in a non-reappraisal year. The county's valuation is I got it right here. The county's valuation on the real property is $79,871,256. The taxpayer says it should be worth I wrote it down, 40, I think it's $49 million. We've wrote down a lot of notes here. And it's the argument is that the base values from 2018, which is already at appeal, are flawed, and the schedule. So if the PTC changes the values for 2018, it'll change the values forward. And I don't think the taxpayer, in my opinion, we have the ability to decide whatever the value is, but neither the taxpayer nor the county is really making a lot of arguments as to what individual components of this real estate should be. They have to appeal this in order to move up to the Property Tax Commission, or else they'll waive their rights for 2020 forward. Does anyone have any thoughts on this one?
I move that we go along with the county's value and deny the appeal.
All right. And is there a second to that?
I will second it.
All right. Let's have some discussion on that one. Does anyone want to go first? All right, I'll go. I think that's the right thing to do. I don't know what the ultimate value of this real property is going to be. I think that they just need to do this to move up the ladder and preserve their appeal. And I really appreciate the parties in saying that. The county's value to me is presumed to be correct. I don't know if it ultimately will be correct, but because it's based on stuff that cannot be determined at this time, I think that is our obligation to uphold the county's valuation and not try to get into the weeds as to what it actually should be. Even though that is kind of our job on properties, but in this case, we're building on an appeal that's already been there, and this is procedural. So I'm going to support the motion. Does anyone else want to be heard? All right, that said, the motion is to accept the county's valuation for 2020 real property on the Patheon tract of $79,871,256. Roll call vote, please.
Chairman King,
I vote in favor. I vote to uphold the county's valuation.
Commissioner Congleton,
Ed Compton votes aye.
Commissioner Shepherd,
John Shepherd votes yes.
Commissioner Smith,
I vote yes.
Commissioner Shackelford.
Yes.
All right, so 2020 real property, the valuations are, it carries. That is a unanimous vote. We'll see what they do at the PTC, and we'll see when the arguments are made at a level above us. The next items that we have are the 2019 and 2020 business personal property tax. Similarly, the county's value for 2019 is $243,157,828, and the 2020 valuations is $288,116,228. It's the same thing as far as evaluations go. The taxpayer has to make the appeal in order to preserve their appeal rights at the PTC. Once again, it's based on earlier valuations. There could be arguments about the new things that were added or not added, but I think we're all pretty clear that the argument is that the actual DOR schedule of values is flawed in some ways. So does anyone have an idea of what they want to do with the 2019 and 2020 business personal property?
I move we accept the county's value for 2019 and 2020.
All right, is there a second to that? Is there a second to Mr. Congleton's motion?
I will second it.
All right, does anyone wish to discuss? All right, I think we're ready for a roll call vote.
Chairman King,
I vote to approve the county's valuations for both 2019 and 2020.
Commissioner Congleton,
Ed Congleton, yes.
Commissioner Shepherd,
Mr. Shepherd votes yes.
Commissioner Smith,
Yes.
Commissioner Shackelford.
Yes.
And so the motion carries unanimously to uphold the county's valuations for 2019 and 2020. That the chair would say that in no way implies that the arguments for both sides weren't good. This is just a more difficult issue that is moving up the chain. It's a little bit bigger than our board, and we'll be fascinated to hear the ultimate result. And I do appreciate the parties taking those positions. Now we get the one that we actually get to decide, which is the penalty on the 2019 listing of business personal property. As both sides have conceded, we do have the ability, using with some kind of equitable powers we have, the statute grants us the ability to compromise the discovery. The amount of the penalty for Patheon for its late listing in 2019 is $195,905, I believe. We could say that the penalty stands and assess them 100% of the penalty. We can waive 100% of the penalty, or we could split it somewhere in the middle. And it is within our discretion. We're allowed to do that. The taxpayers' arguments is that I'm not even sure. The taxpayers' arguments is we messed up. We sent in a faulty tax listing form. I would add that they sent it in actually it was sent in on time, but it didn't have the right taxpayer and it didn't have the right amounts of listing. Someone just screwed up, which is always good to admit when people screw up. The county's kind of rebuttal is, yeah, they screwed up. It made it difficult for us to budget. We issued a bill because we had to issue one. We had to go through the rigmarole of getting it released with the county. And yes, it's their fault. Yes, we're thankful they said they screwed up, but they should have to pay a penalty because other taxpayers filed theirs properly and did it. And, we had to go through this struggle to get it corrected. So they should be subject to the penalty. So it is within this board's discretion to decide what to do with the penalty issue. I think you guys understand the arguments. Does anyone want to make a proposal?
I move we reduce the penalty by 25%.
And charge a 75% penalty?
Yes.
All right. Is there a second to Mr. Congleton's motion? Hearing none, that dies. All right. Does anyone else want to give it a shot?
I agree with Mr. Congleton that it should be reduced due to the extenuating circumstances. Exactly how much is the question.
That would be a time for a motion, Mr. Shackelford, on that one. You could, Ed didn't get it. Ed didn't do it with 75%. So it's somewhere between 0 and 100%.
Well, the county certainly endured extra costs associated with this. So I certainly would need to cover that, but I have no clue what those are. So if anybody has
Take a stab.
what the extra cost burden was on the county for this.
Hold on real quick. Hold on. Hold on. That's the risk of justice with a Zoom meeting. Your children come home.
Well, I
heard
guess,
that- Oh, let me, so Mr. Shackelford, you don't know what the costs are in that one. Do you want to take an estimate on, I think Mr. Congleton is right in the percentage basis. So do you want to take another shot at the, at a percentage on that? If he's looking to put actual costs in there, I'm not sure that they're going to be coming in. So.
Well, if we're gonna, I'd say maybe 50% instead of 75%.
I would second 50%.
Jeremy.
Go ahead. John, you want to be
I have a
recognized?
question on this before we get into the second or whatever else it is. What is the total amount of their penalty?
It's $195,905.
195. Okay,
So 50% would be still, they would still be paying a penalty of, you know, approximately $97,500.
okay, I'll second the motion.
All right, well, I'll let you second it then. So we have a motion on the table to reduce the penalty by 50%. Does anyone else wish to be heard on this motion? All right, well, we're ready for a roll call vote.
Chairman King,
Chairman King votes in favor of the motion to reduce the county's, to reduce the penalty by 50%.
Ed Congleton,
Ed Congleton votes no.
You vote no? Okay,
I vote no.
all right.
John Shepherd,
John Shepherd votes yes.
Danny Smith,
Yes.
Jay Shackelford.
Yes.
All right, the motion carries 4-1. The penalty has been cut in half. All right, I think they call that splitting the baby. So with that said, I believe that we have dealt with all the Patheon issues today. And I want to thank Mr. Adhan and Mr. Reese for their excellent advocacy for their clients. And please keep us posted as you guys go up the ladder. Thank you. Let me move to my agenda real quick. And
I want to thank everybody for letting me appear by video, and it was an excellent meeting and well run, and there were absolutely no hiccups on my side of the video and all. It was very well done. And John, thanks for your consenting to my appearing by video also.
Not a problem. And if I could just say, Mr. Chairman, appreciate the board hearing us and other members of the board. Appreciate your time in hearing us today and appreciate your consideration of the cutting the late listing penalty. We appreciate that. Thank you.
thank you, gentlemen. We appreciate it. Give me a second to pull up my agenda because I was looking through the material sent by Patheon. So let me pull that up real quick. Oh.
Chairman King, did you, I was just talking, did you call on anything from the clerk?
No, I was going to say, we have more appeals scheduled for today. I know I want to pull up my agenda. Is it okay if we take a 5-minute recess? I think, would that be good for you guys as well?
Absolutely.
Yeah,
All
that'd be
right.
great.
I normally would do that when I'm there. I can't gauge it, but I've got to, let me pull up my agenda and let's be in recess for 5 minutes. Family?
Jeremy,
Ed,
when are you getting back home?
looks like they come back on the 3rd and I'll get home on the 4th because I got to spend the night. The flights aren't back yet regular.
Wow.
Hey, Ed, you can't hear, my daughter jumped in the shower behind me while I was went to recess.
Oh,
All right.
Chairman King, we're ready to go whenever you are.
We're ready right now. I've got my agenda pulled up and I appreciate it. I know you guys probably needed a 5-minute breather yourselves. So with that said, I think we're ready for the next item. You know, according to my agenda, it is A1 Hospitality LLC. It's a real property value appeal for parcel number 11961. Someone from the county be telling us what is going on with this parcel?
That's correct. Rod Towell is coming forward.
Before he comes up, Mr. Tugwell comes up, is somebody from the taxpayer present?
That's correct. Attorney John Cocker-Reese be representing A1 Hospitality LLC as well.
Mr. Cocker-Reese, does your client consent to the remote hearing?
Yes, Mr. Chairman, he does.
All right, well, let's roll forward with it.
Okay, so this is for parcel A1 Hospitality, parcel 11961. We have reached an agreement on a valuation for 2020 for this property, and we just want to submit that to you for your approval.
All right, what's the valuation that the county and the taxpayer have reached?
Okay, the new value is $1,810,236.
$1,810,000.
And 236.
All right, so we have in front of us a valuation for this parcel number 11961, and the valuation is $1,810,236. Mr. Cocker-Reese, does the taxpayer agree to this valuation?
Yes, Mr. Chairman, he does.
All right. Does anyone from the board have any questions for either the taxpayer or the county? These parties have come together and have consented to a value. I mean, we certainly could inquire as to why they wanted to do that or ask questions, but my modus operandi is to not do that. So does anyone have any questions for either one of them? All right. So in front of us right now is the value. I'm going to go ahead and close that. I don't think it's any evidence to be taken, but I'm going to close that. In front of us is the valuation for parcel number 11961. The county and the taxpayer have agreed the valuation is $1,810,236. Because the Board of Equalization and Review has convened, the county does not have the authority to approve the valuation and must require our authority. I think we are ready for a vote.
Chairman
Move to
King,
accept the county's value.
All right, second, just in case that's needed. All
I'll
right.
second.
All right. Roll call vote.
Chairman King,
Approve. Yes.
Ed Congleton,
Ed Compton, approve.
John Shepherd,
John Shepherd approved.
Danny Smith,
Approve.
Jay Shackelford.
Approve.
All right. Motion carries 5-0. Good work, guys. Good job on the compromise. All right. The next one we have in front of us is Joy Real Nethercut. It looks like it's 3 parcels of Pitt County land. Parcels number 47810, 47811, 47814, and 47809. Is anyone from Miss Nethercut present?
Ms. Nethercutt is present.
All right. Miss Nethercut, if you could approach the podium or the stand where people have been testifying from.
And
Unfortunately, I don't have the ability to see you, but Ms. Nethercutt, this hearing, because of the there you go. Thank you. Because of the coronavirus, we are having what's called a remote hearing where some of us are not present physically. We are present mentally, hopefully, and we can listen to your appeal. But in order to proceed, you must agree to the remote hearing. Do you consent?
I do.
All right. Well, I'm going to let the county tell me a little bit about your parcels first, and then I'm going to let you come back up and present your evidence and tell us why the county is incorrect and tell us what you think the value should be. And you can present any evidence that you like, but I'm going to let the county's valuations are presumed to be correct. So I always like to hear what the county says the value is first. So with that said, will someone be presenting for the county today?
Yes, Chairman King, Russell Hill for the county.
they will. And Chairman King, can we swear Russell Hill and Ms. Nethercutt in at this time? Go ahead.
That
swear
sounds
in.
like an excellent idea. Why don't Ms. Nethercutt and Mr. Hill be sworn in so they can give evidence?
Would each of you raise your right hand, please? Do you affirm that the testimony you shall give to the board shall be the truth, the whole truth, and nothing? Thank you.
All right, Mr. Hill, I'm going to write down these separate parcel numbers. I have a feeling they're all related, but I'm going to write down the parcel numbers and we'll go through them as in the order on the agenda. 47810. It's my first one I've got. 47811. 47814 and 47809. So tell us about Mr. Nethercutt's parcels.
Okay, these are condos out in the Treetops subdivision. They all are the 811 square foot condos. She owns 4 properties. They are, if I'm not mistaken, they're all identical. They're all the same. She is appealing and think the value should be around $67,800, and the county currently has an assessed value on the properties of $72,807. I'll just say 72,000, around 72,000. There's a slight difference just depending on if it's a patio or wood deck on the property. But essentially they're all the same. In the packet I've given to you and the board, the first few pages are the information that Ms. Nethercutt provided through the informal and the board appeal for each property, and that covers pages 1 through 9. Starting on page 18 is her documentation that she provided that we reviewed. And she's saying that based off of the sales of the condos out there, that there were 4 sales, I do believe. There were sales, I think, of 4 at $67,500. 1 at 86,000 and 1 I think at 57. And the way we've looked at these properties, like I said, they're all the same. And in doing our analysis of the market out there, what we noticed was what I did, I looked at their pretty much, like I said, all the sales that took place in the 2019 tax year, which is starting on page 21 for the board, is kind of where I'm starting at. We had 7 sales that we kind of looked at for in my analysis. They took place between the tax years of 2017 through 2016. Typically, we will use the sales that took place in 2019. And that's because we want to get the most current market value and that's going to give the most current sales. Out of those sales, 4 of them, 4 took place at 67.5 and 1 took place at 86,000. And by doing my market analysis of that property, the ones that sold for 67.5 were pretty much original. Some had some paint updates, some had some laminate floor updates, some had, the original brown trim around them. And the one property that sold for 86,000 had granite countertops put in it, had laminate floors for what I could tell throughout. And then I had to make a decision on how much contributory value did I think that remodel of that unit did. Because typically we would use the median value, which would be 67.5. But with the market as hot as it was at the end of the year, we saw a 5 to 6 to 7% increase in properties throughout the county just from August to December. So I think so in this case, I did a weighted mean or weighted average to come up with my value. I did several things. The first thing I did was a weighted. I wanted to weight because I think if you use the median, it's going to kick out the $86,000 sale. But I think it should be used to help determine the value of those other condos. Because with the market going up, that was the last one. And the other one sold right prior to it was just 3 days. So you had one sale for 67, one sale for 86. So that's a value of about a $19,000 difference. And the question I had, and I talked with my other real property manager, Rod Tugwell, about it, I said, I don't think that's $19,000 worth of value in granite countertops and laminate floors, paint, and crown molding. I said, that is 811 square feet. That's a tremendous amount of additional value that I think we need to, I think part of it is the remodel and part of it is the market still continuing to move up. So instead of going to so I looked at it that way and I used a weighted average giving, since the majority, 4 of the sales were 67.5, I gave 25% weight to that $86,000 sale. And I gave 75% to the 67.5. And that works out to be right around $72,000 again. And I said, well, let me look at time adjustment factors to try to get a little bit better sample into the property, get a few more sales. And that's what this worksheet on 21 did. I used a 0.67, just looking at the treetop condos, trying to look at paired sales and the adjustment over time. And that gave, if I included everything on this sheet, the median value comes out to $69,619, and the average works out to be about $73,536. So using all the sales and and recognizing that the market was going strong, we put the value on these properties around $72,000 for each one of them. And that's how I arrived at that value. And I would also like to point out that even the owners that paid $67.5 and the one that paid $57 and $19, none of those have appealed that $72,000 value that we have put on the properties.
Russ, let me ask you a question. Was the $57,000 sale in 2019 as well?
Yes, sir. That is the one down at the bottom. And I got a note right above it that I did not use it in this analysis because it did skew those values. So I took it out.
Why was the $86,000 sale was used, but the $57,000 wasn't? Was it not an arm's length transaction, or is it?
I did not find that in the open market. Of course, we don't have MLS. When I searched that sale, I didn't find that in Zillow. I did ask one of the appraisers that have MLS, and he said all he found was expired listings. So that's the reason why I also removed it out.
Okay. And when
I'm
was,
not gonna say it wasn't a arm length transaction, but it didn't go through the typical MLS like the other ones did.
did you just see the stamps on the deeds? Is that all you saw?
Yes, that's all that I have access to, but then I did have somebody to verify because it was so far out of line. You know, if it was 62, I wouldn't have questioned it, but 57, I'm like, that's a 10,000. Because I figured either one or two things, either it was physically damaged, somebody got a great deal, so there was something else behind it. I couldn't, so and our office is considered a qualified sale, but I did remove it out of this analysis. I'm not gonna say it's disqualified because I can't find anything to disqualify it, but I think it's, I do believe there's something going on and it didn't go through the normal transaction of MLS.
Let me ask you a question. The $86,000 unit, which sold in 2019, you said it had granite countertops and crown molding, some features that, you know, aren't so typical features for an 811 square foot, $72,000 condo. Do you know if Miss Nethercutt's properties have any of those additional features, or hers kind of like the standard grade ones that have not been? Did you individually investigate whether she had any extra features in there, or it's just calculated into the weighting of the $86,000 one in your calculus?
It was calculated there. I figured everybody was somewhere probably in between. Either they've maintained it or they've painted it, they've done something, but they may not have done the full upgrade of the 86,000. And that's the reason why I didn't put, even the house that sold for 86,000, I'm sorry, is valued at 72. I've treated them all the same.
I understand.
Russell, do you know how much these properties are leased for?
Based off of the market rents that I could find, they're about $750, I think was, let me look at my opinion of value real quick. Because I did look at the income on them. It was about 740, the few that I did find rented in the market right now.
Do you know
And
Miss
Miss Nethercutt's, I think was a little bit less. And in her property, I think it may have been, I've got that information if the board want me to present it. I didn't put it in this packet just because of the fact that this was public record, but she did provide that information.
Okay.
She probably could definitely give the exact amount when she presents hers, but I want to say it was like $720.
What are the monthly maintenance fees there?
I'm not sure on that part. That's Ms. Nethercutt could probably answer the HOA dues and different things there. I can't say exactly what they are.
All right. Does anyone on the board have anything else for Mr. Hill? And Mr. Hill, can you give me, I'm at a little bit of a disadvantage, but can you give me the actual value that the county said? They're actually all the same at 72,807, or they actually vary a little bit?
They vary a little bit. Parcel number 80, let me make sure I got Miss Nethercutt's here. Miss Nethercutt, parcel number 47,809.
Yep.
Parcel number 47,810.
Yep.
And parcel number 47,811 are all valued at $72,807. And parcel number 47,814 is valued at $72,799.
All right. So we got $8 of difference in that one. I do think I actually need those on there, but don't go too far away. We're going to let the taxpayer present her case and take some evidence. If we have some more questions, we'll ask you. Unless does anyone else have anything for Mr. Hill? Okay. Ms. Nethercutt, you can approach the podium. You have been sworn, and you can present your case as to why your parcels are not worth $72,807. And I would ask as a favor to me to tell me what you think each of these parcels are worth. And if it's the same amount for each one, that's good too.
Okay, thank you. I'm Joy Nethercutt. Thank you for letting me have the opportunity to speak to the board today. I have some more information that to add to what has already been presented. I live out there in Treetops, and I have 4 rental properties out there that we're talking about today. 3 are first floor units and 1 is a second floor unit. So that's where the difference, the $8 difference is. There are 48 condos out there in 6 buildings. Each building has 8 condos in it. More than half of these condos are owned by people like me who are renting them out. So many of the condos are in either their original condition with paint and carpet as needed, and appliances as needed, because they're rental property. The only one that, to my knowledge, that has granite countertops is the one that sold for $86,000. And that was a special situation where it was outfitted that way. The one that sold for $57,000 in October of 2019, that one was purchased by another owner of a rental property out there who knew that that property was being, it had been upgraded to some degree, but he did a transaction without going through MLS. So that's why it's not showing up in MLS. But it was an arm's length transaction. So I know both parties, the buyer and the seller. Also, there was a transaction, there was a sale in January for $61,000. Again, that was an arm's length transaction. Another investor out there who already owns a couple of units knew that the young man who owned that one had taken a job in another county and was going to leave. And so he approached him and said, would you sell yours to me? That one didn't go through MLS, I don't think, as well. So the ones that did go through MLS did sell for $67,500. We have 2 that sold, one in October, one in December for $67,500. So there were 5 comps in the last 6 months, right there jammed together. So what I did was I took those 5 comps and divided by 5, totaled them up, divided by 5, came out with 67,800. So 67,500 is about where the market is on those condos out there. So they are not, in general, outfitted in laminate floors and granite countertops and all the bells and whistles. They're not done that way because most of them are investment properties. On mine, I have put carpet in and changed the appliances and painted as needed because they are a rental property. So the condition of mine is about the same as most of the others out there. So I believe that instead of 72,800, mine would be worth 67,800 fair market value.
Ms. Nethercutt, your calculations took into consideration the $57,000 sale and the $86,000 sale
I did.
and the 3 $67,000 sales.
Yes.
All right.
67. Yes. I have pictures if anybody needs to see them of the interiors and the exteriors.
Can you confirm your lease rates? Is that it?
Yes, the HOA board went up on the dues to 158 and some change and an assessment. So I had to go up to 725, what I thought the market would bear for the condition of what I've got. There are a few that do go for 750. Some of them are still below 700, in the 600 range, 650. So.
Okay, thank you.
All right. Does anyone from the board have anything for Ms. Nethercutt?
I also have some other sheets to pass out. This is the floor plan on the back and then the spreadsheet on the front.
Somebody like to see these?
Sure.
Does anyone from the board have anything else for Ms. Nethercutt?
I guess my question is to Ms. Nethercutt and also to Russell. The $57,000 sale, do you have any idea whether that was a distress sale?
I think Ms.
No.
Nethercutt testified that it was not, that there was no commission paid on it. It wasn't from the MLS, but it was from people that already own properties out there.
Okay.
And Mr. Hill testified that he didn't know because it wasn't in the MLS. He doesn't have access to the MLS, but it seemed odd to him. He couldn't determine any information on there. So that's why the difference in the values are whether or not you include the $57,000, and he excluded that sale and she included it. So I think they both have already testified as to that. Can I see the board? Can I see the camera angle of the board again?
Can you see us, Jeremy?
Yes, now I can. I was enjoying looking at Ed there, but I figured I probably ought to go back to the board to see if you all finished reviewing Ms. Nethercutt's materials? Does anyone from the board have anything else for Ms. Nethercutt or for Mr. Hill? All right, I'm going to go ahead and close this hearing to evidence. This hearing is a 2020 real property valuation appeal. It concerns the real property values of 4 separate condos in Treetops. They are parcels number 47810, 47811, 47809, which are all the county's value, which is presumed to be correct, is $72,799, and then parcel 47814, which is $72,807. So there's an $8 difference on that one because of some differences there. So, but substantially speaking, the values are identical on these 810 unit 811 square foot units. Mr. Hills presented evidence of comp sales. The 3 sales that took place at $67,500 and the $86,000 sale. Ms. Nethercutt has also presented evidence, but she has included the $57,000 sale that took place in 2019 and has said that it was, even though it wasn't on the MLS, it was an arm's length transaction between a willing buyer and a willing seller. And the differences between their values is that Ms. Nethercutt believes that the $57,500 sale should actually be calculated in there and not excluded from the formula. Mr. Hill did discount for the $86,000 sale, using it only as a 25% multiple, but that's what's yielded the difference. The difference is Ms. Nethercutt is asking for $67,800 in valuation for each of these units, and the county's valuation is at $72,807, which is approximately $5,000 more. In any of these appeals, we have to decide whether or not the taxpayer has met her burden to show that the county's methodology or their valuation is incorrect, and whether or not the incorrect valuation is actually material. Each commissioner has to decide whether or not they believe the dollar amount is material. But if the taxpayer meets their burden to show that it was irregular and presents evidence of such, then we are allowed to consider that. So with that said, this is something we have the right to decide the valuation. We can choose whatever value we want to put on it. It's a reappraisal year. This is what we're supposed to do. You guys have heard the evidence. I would suggest that we decide that the valuation is somewhere between $67,800 and $72,807, because those are the two parties have asked for those valuations, that it be somewhere in between there, either at one end or the other. Does anyone wish to be heard on a motion?
I got a point of order. Since Ms. Nethercutt actually handed out information, should we consider this, and maybe Attorney Smith can speak to this?
Sure. So the law on remote hearings for quasi-judicial proceedings does say that all board members need to have the documents considered. With that being said, I assume that is something that could be waived by the taxpayer if she's agreeable to do so. I'm not going to comment on the evidence. It seems to me that there was enough evidence presented in the form of testimony that the board could base their decision upon that. But ultimately, I would say that I would feel more comfortable if the taxpayer would again consent to the board proceeding with knowing that the two members participating remotely were unable to review her documentary evidence, but did hear her oral testimony.
Ms. Nethercutt, what Mr. Smith is saying is, because of the irregularities of having a remote hearing, you presented some evidence to the board. And I think you presented them a floor plan of your units and some other units. And you also presented a spreadsheet, which in my estimation has all of the comp sales you just testified to and shows how you divided them and came to your valuation. What he's asking you is, we would like you to consent for us to make a determination on this appeal without looking at your evidence physically, because Mr. Congleton and I are not physically present there. But it is your right to not consent to that. And then we would consider that we would come back to Greenville when we get back to Greenville, and we would hear it on June 11th. You would not have to present it again. We would just look at your evidence and we would decide. Or you could consent and decide that Mr. Congleton and I may be able to make a decision without looking at your documentary evidence. I'm going to let Mr. Congleton speak, but for me, I have enough evidence from your testimony and from Mr. Hill's testimony that I feel like I'm able to make a decision, because I think you guys use the same comps. So it is up to you. Mr. Congleton, do you want to add something to that?
I agree with you, Mr. Chairman, that the testimony that she has presented, I accept what she's presented. I don't have to see the documents.
All right, Ms. Nethercutt, it is up to you to decide whether you wish to waive your right for us to review that in person and let us make a decision without seeing the documents, or we can determine it on June 11th when we come back. It's up to you. And we want to make sure that you feel like you're being treated fairly and the county feels like they've been treated fairly. And it is just up to you.
We can proceed today.
Thank you, Ms. Nethercutt. All right. So we've got the evidence that the taxpayer submitted, and we've got the evidence that the county submitted. Does anyone want to make a motion on this one?
I will make a motion.
What is it, Mr. Shepherd?
I think both parties have made a very good argument as to the homework that they've done and the values that have been presented. So I'm going to make a motion that the county's assessed value be upheld.
All right. Is there a second to that motion? Hearing none, that motion dies. All right. I'll give it a shot, and I might not get a second either. I'm going to make a motion that we accept the taxpayer's valuation of $67,800. And I'll see if there's a second to that. Is there a second?
I second that.
All right. I'm going to take Danny's second on that one. And since it's my motion, I guess I'm the first one to be heard. I think Mr. Hill did a good job, but he did not have his disposal. He could not validate the $57,000 comp. And so he excluded it 100% from there. I'm swayed by Ms. Nethercutt's knowledge of the market. And I also know that she's in real estate and that she would have access to these sales. And I'm swayed by her testimony of being out there that the $57,000 transaction was actually a legitimate arm's length transaction. And I think you ought to include the $86,000 one and the $57,000 one, along with the $67,000 ones. And so I think that she's prevailed in her case, and I would support the taxpayer's appeal. Does anyone else want to be heard?
I agree. It would appear that the $86,000 one is due to primarily to the upgrades that her units don't have.
All right. Anyone else want to be heard? And I would just add, this has nothing to do, this is, Mr. Shackelford, this might be for your benefit and for everyone else's. So the two components is that we find that the county's valuation is wrong, which I believe that it is wrong in this one, but also that it be materially wrong. And in this case, it's only $5,000. For me, if it's not at least 5%, it's not material. But every commissioner, I want to ensure that you have the discretion to make up your own mind about what is statistically material, right? You know, if it was $5,000 and this was a $100,000 property, I would just approve the county's valuation. But since it's a $67,000 property, this one's on the borderline for me, right? And this has nothing to do with whether we should approve it or not, because I think that we've always said that's kind of in your own mind, what's material. You know, if someone comes up and they want to get $1,000 off on $100,000, I don't think it meets that statute. I think this one does, but I do think it's close. So I did want to say that.
There's also the fact that there are 4 of them, so it ends up being 20,000.
Yes, but I mean, we're not just that. When we set this value for this property, it may affect the values of the other units around there. So it may affect not just these 4, it may affect other ones which are out there. So, I mean, when we do this, we do it based on the evidence, but it's, you know, it can have longer impressions than just who we're dealing with. So does anyone from the board have any more discussion on the motion? All right, hearing none, I think we're ready for a roll call vote. And the motion is to approve the taxpayers' valuation of $67,800 for each of those 4 tracks.
Chairman King,
I vote for the motion.
Ed Congleton,
Ed Congleton votes aye.
John Shepherd,
I vote no.
Danny Smith,
I vote yes.
Jay Shackelford.
Yes.
All right, that motion carries by a margin of 4-1. Let's see what our next, oh, and thank you, Ms. Nethercutt and Mr. Hill. You know, both of y'all did an excellent job. All right. Let's go to Timothy Michael Crouchley. That is real property parcels 44676 and 44672. Is there a representative there for Mr. Crouchley? Is anyone there?
Yeah, Mr. Crouch is coming to the podium.
You affirm that the testimony you shall give to the board shall be the truth, the whole truth, and nothing but.
Yes.
Thank you.
All right, Mr. Crouchley, before we begin, I think you've already heard this. Because of the COVID-19 measures, you must consent to a remote hearing. If you don't consent, you can come back on June 11th, no harm, no foul. But if you want to, and you're confident in the process from having 2 commissioners appearing remotely, and you wish to proceed today, you can consent and we'll go for it.
I consent.
All right. I'm gonna let somebody from the county tell me about your parcels first, to tell me what their value is first, and then I'll let you come up and tell me what your value is. So who's up for the county?
Russell Hill for the Pitt County.
Mr. Hill has already been sworn for a prior appeal. I don't think he needs to be sworn again. Jordan, I don't think he does he?
That's the same advice I gave Ann earlier this afternoon. So no, I don't think he needs to be sworn again.
All right. Russell, you can tell me about Mr. Crouchley's parcels, and they're parcel number 44676 and parcel number 44672.
Okay. These are also 811 square foot condos out in Treetops. They're essentially the same as Ms. Nethercutt's, and the value for parcel 44672 is $72,807. Parcel number 4476 is valued at $72,799. And the county has no additional information to present to the board because it's the same information that was provided in Ms. Nethercutt's appeal.
Thank you, Mr. Hill. And once again, I think you did a good job on these things. It's just a difficult one with that bad comp. Mr. Crouchley, do you come up to the podium? Now, you've seen Ms. Nethercutt's appeal, and you've heard what the board's decision was on Ms. Nethercutt's appeal, and the county has said it has nothing more to add. Do you wish to add anything?
No, she did a great job, and we're talking about the same properties. I have 2, she has 4. She might have used 1 extra property than I did. I came up with a value. I averaged out the comp 67,750, but 67,800, like you agreed with her, I'd just be fine. Just be done with it.
I think that is probably, I can never tell what the board is going to do, but I think you're probably reading us correctly. So does anyone from the board have anything for Mr. Crouchley or Mr. Hill? Okay, I'm going to go ahead and close this hearing to evidence. Guys, we have in front of us parcels number 44676, 44672. They are treetops. They are identical. There is no evidence had, and we just voted to set the values on identical ones at I got to flip the page, at $67,800. Does anyone want to make a motion?
Make a motion, we do the same.
All right, I've got a motion from Mr. Shackelford. Is there a second to that motion?
I second it.
Danny may second it. All right, is there any discussion on this one? Hearing none, the motion is to set the values for parcels number 44676 and 44672 at $67,800. I think we're ready for a roll call vote.
Chairman King,
I vote aye in favor of the motion.
Ed Congleton,
I vote aye, yes.
John Shepherd,
I vote no.
Danny Smith,
Yes.
Jay Shackelford.
Yes.
All right, gentlemen, we are done with that appeal. And I would say that sometimes as a judge, you want to be consistent. That is an example of being consistent on that. And I do appreciate the taxpayers and the county for not relitigating that last one. That brings us on to the next appeal, which is Curtis Williams and Hattie Williams, real property parcel 12198. All right, is anyone there for the Williams?
I do not see anybody present, Chairman King.
All right. If anyone can hear me, if anyone is there to speak on behalf of Curtis Williams or Hattie Williams, present yourselves. All right, I'm going to guess. I can't see everyone, but I say, seeing no one. This appeal, we're going. I don't know if I'm going to take a motion for it because the COVID-19 statute requires consent. We can't dismiss their appeal or hear it in their absentia. So we're going to have to move this appeal to the June 11th calendar. Jordan, do you think that requires a motion? Should we do one just in case?
I was typically, I'd say no, I don't think it does, but it doesn't hurt to do a motion.
All right, the chair would make a motion to, because of the lack of consent for a remote hearing, the chair would make a motion to move Curtis and Hattie Williams' appeal to parcel 12198 to June 11th session. Is there a second to that motion?
I'll second.
All right, I didn't, was that from you, Danny?
Yes, sir.
All right, is there any discussion on the motion? Hearing none, we'll take a roll call vote.
Chairman King,
Approve for motion.
Ed Compton,
Ed Compton votes aye.
John Shepherd,
John Shepherd votes yes.
Danny Smith,
Yes.
Jay Shackelford.
Yes.
All right, now that brings us to the last appeal. That is the Robert Carl Kemp III and Michelle Lister Kemp. That's parcel number 22163. Is anyone for the Kemps present?
Chairman King.
Yes,
Let's talk with Russell Hill.
yes.
The Kemps are not here today and they have requested that their appeal be heard on June 25th.
Okay, I think that would be fine with, I think that'd be fine with the board. And let me note for the board, I want to be on the record for this one. I will have to recuse myself from the Kemp appeal. I know I'm here right now, and had they been here, the Kemps are, Mr. Kemp and the Kemps are friends of mine. I've not discussed this case. I did not know they had an appeal until today, but I've actually advised them in a legal capacity on their property itself. That's the property subject to us. So I have, I don't know what their appeal is all about, but I do know about certain aspects of their property that would make it inappropriate probably for me to weigh in on what I thought the value was. And I'm confident that on June 25th that the board can make appropriate decisions. And I will certainly be there to hear all of the other appeals, but whenever that one comes out, I will bow out of the conversation and the vote. So I'm pretty sure since the taxpayers requested it to be continued, we don't need to vote on that. So that said, bring us down to the item of new business.
Okay.
I didn't get a chance to get.
Okay. Okay. Ann Heath just brought to my attention on the packet, as far as the board members present, there's a consent agenda item. But we do not have consent from these taxpayers to hear this case today either. And maybe it would be best to postpone this to the June 11th. And Russell Hill's coming up. Maybe he has some different information than I have.
Yes, Chairman. These, like Sam said, these are consents. We do have, these are ones that appealed informally or after the board convened and we've actually settled and reached an agreement with them. And we do have a signed letter saying that we've all come, us and the taxpayer have come to an agreement, but if the board will want for us to wait to June the 11th, we can present that at that time. Or if, but that's what these are. These are ones that we just statutorily have lost the power changed their value now.
And Chairman King, I'll just chime in. This probably seems totally pedantic and academic. Sounds like we have the taxpayers' consent as to the value. However, I'm not sure we have the consent for y'all to hear their value in a remote setting. Probably is not a lot of risk to hearing it, but I would recommend that we try to obtain their consent via email. Staff can do that and probably could just put it on as an item for consent at a future meeting.
Let's put it on let's move that to the June 11th agenda. Either we'll all be present, but let's see, just in case, you never know. We have no idea what's going to happen between now and June 11th. Let's see if we can get their consents to consent to a remote hearing on their consent. Let's see if we can get that in the record and be prepared to do that then. But I don't think that it will upset the apple cart too bad to wait from today until June 11th to approve the consent agenda. Does that sound reasonable?
Yes.
All right. Do we have any other new business?
We do not.
All right. Well, our next meeting, as we just discussed, is Thursday, June 11th at 4 o'clock. I will be there in person, and hopefully we'll all be able to be there in person. And I say that subject to anything new coming up that makes us not be able to be there in person. But June 11th at 4 o'clock, we'll have some more appeals and a consent agenda, and I'm sure we'll have minutes to approve. So I look forward to seeing all of you guys in the flesh, ladies too, in the flesh when we get to there. Does anyone from the board have any more comments for today?
Happy landings.
Well, I do want to make a comment. I want to say thank you to the staff, the technological staff, the county, the tax administration, the taxpayers, to Jordan. I really have enjoyed this one. This has been the best hearing I've had. Being an attorney, I've been having to do these hearings occasionally, and I really appreciate the level of assistance that Mr. Congleton and I got today. And although I don't like not being there, I really feel like we did a good job today, and it's not due to me, it's in spite of me. So thank you, staff and county, and I look forward to seeing you guys in a couple of weeks. With that said, we're not going to adjourn. I'd entertain a motion to recess.
Also motion.
I'll
Second. All right, I got it. Is there any discussion? Hearing none. Roll call vote, guys.
Okay. Chairman King,
I vote yes.
Ed Congleton,
Ed Congleton, yes.
John Shepherd,
Yes.
Danny Smith,
Yes.
Jay Shackford.
Yes.
Motion carries unanimously. I will see you guys on June 11th. Thank you.
Does this stuff stay?